So picture this scenario for a second. It is 3 o'clock in the morning.
Oh, the classic late night negotiation.
Right, exactly. You're in this glass-walled conference room in Midtown Manhattan. A corporate acquisition, I mean, we're talking $500 million, is just sitting on the table.
And everyone is completely drained.
Completely. The business teams have been negotiating for, what, 6 months? The coffee went cold hours ago. All anybody wants to do is sign the papers and go to sleep.
But they can't.
No, they can't. Because the entire deal is completely stalled. And why? Because the buyer's lawyer and the seller's lawyer are in an absolute screaming match
Go for a comma.
over the placement of a single comma. Or, whether the word including means for example, or this is the entire list. I mean, to anyone outside that room, it looks like absolute insanity. A $500 million transaction held hostage by grammar.
It really does look crazy. But to the people inside the room, it is the exact opposite of insanity. I mean, it is pure survival.
Survival over a comma.
Absolutely. Because that single comma or, the specific definition of that one word could easily dictate whether one of those companies absorbs a $50 million liability down the road.
Oh, wow.
Yeah. So it looks like pedantry to a layperson, but it is actually this incredibly high-stakes risk allocation.
And that is exactly what we are dissecting today on this deep dive. Welcome in, everyone. Today we are taking a definitive masterclass on the art and really the science of drafting clear contracts.
It really is a science.
It is, and we're anchoring this heavily on the framework of contemporary commercial drafting by Tina L. Stark. The goal here is to understand the microscopic dispute triggers that cause massive agreements to just fail completely.
Right. We want to eliminate ambiguity. We want to spot those hidden legal traps that, frankly,
Even a lot of lawyers, right?
Oh, especially a lot of lawyers. Traps they just never see coming.
Which is such an essential skill because, and this is a concept from the sources that I loved, a contract is fundamentally a piece of private legislation.
Yes, that's a great way to put it. Private legislation.
Right. You are writing the laws that will govern a very specific universe, just the relationship between these parties. And if the laws of that private universe are vague, the whole relationship collapses the second there's friction.
It does. It absolutely crumbles.
So for you, the listener, and I mean, whether you are a deal lawyer structuring a merger or a founder signing your first commercial lease.
Or just, someone staring at a vendor agreement, wondering why it is 30 pages long.
Exactly. Understanding this completely changes how you view the fine print. But to get there, we really need to address this fundamental misconception about how lawyers actually operate.
The TV lawyer stereotype.
Right. The popular perception of a lawyer is the person in the courtroom, right? Pounding the table, cross-examining a witness.
The litigator.
The litigator, yes. But our sources make this very sharp distinction between the litigator's mindset and the deal lawyer's mindset. And they argue that applying the litigator's mindset to drafting a contract is precisely why so many of them fail from the start.
It's a fatal flaw.
I kind of need some convincing on this, though. Because, I mean, aren't they all just lawyers trying to apply the law to get the best result for their client?
Well, they are, but they are operating in completely different directions of time.
How do you mean?
So a litigator is fundamentally a historian. They look backward. They get called in after a car crash has happened or after an employee has been fired.
After the deal explodes.
Exactly. The event is over. The facts are static. So the litigator takes those static facts, looks at the existing law, and applies the law backward to build a persuasive argument. Their entire objective is zero-sum.
To win. To defeat an adversary.
To win.
So they are basically taking the pieces of a broken vase and trying to argue about whose fault it is that it broke.
Precisely. That is exactly it. But a deal lawyer, the drafter, they are looking forward. They are the architect building the vase.
So they don't have static facts yet.
No, they have business terms. The client comes in and says, we want to buy this software company. We want them to guarantee their code doesn't infringe on any patents. And we want to pay them out over 3 years based on performance.
Just a wish list, basically.
Right. Those business goals are the deal lawyer's raw materials. The drafter has to translate those goals into contract concepts to govern a future that hasn't even happened yet. And crucially, they are doing this cooperatively with the other side.
Wait, cooperatively? I mean, I've seen term sheets negotiated. It does not look cooperative. It looks like a bloodbath.
Well, it is adversarial in the negotiation of the business terms, certainly. Neither party wants to give up leverage.
Sure.
But once the terms are agreed upon, the actual drafting of the document has to be cooperative because both sides share a singular overriding goal.
They want the deal to close.
Exactly. They want to get it done. A litigator wants to destroy the other side's case. A deal lawyer wants to create a framework that both sides can actually live with for the next 5 years.
Ah, I see.
So if you draft a contract with a litigator's mindset, trying to trick the other side, hiding aggressive clauses, leaving things intentionally vague so you can exploit them later.
You aren't drafting a contract. You were drafting a future lawsuit.
You're just setting a trap. Exactly.
That makes total sense in theory. But when you look at the actual output commercial contracts, they don't look like cooperative, forward-looking frameworks. They look like, well, impenetrable walls of text.
They can be dense, yes.
Right. So if the goal is a cooperative relationship, why can't commercial contracts just be written in plain English? I mean, we see a huge push for plain English in consumer contracts, like terms of service or credit card agreements. Why hasn't that translated to commercial drafting?
Because the risk profiles are entirely different. In consumer drafting, the overarching rule is clarity through simplification.
Meaning what, exactly?
Meaning, if a specific risk is highly unlikely to occur, you simply ignore it. You do not draft a clause for a 1 in a million scenario in a basic car loan agreement.
Because the cost of confusing the consumer outweighs the benefit of the protection.
Exactly. And the average person isn't going to negotiate the car loan anyway.
Right. It's a take it or leave it proposition. Sign here, don't get the car.
Exactly. But in contemporary commercial drafting, you are dealing with sophisticated parties moving millions, sometimes billions of dollars. The rule flips completely.
How so?
If a risk can be perceived, no matter how remote, you draft for it. If you are Apple making a massive component deal with Intel, you do not pare the contract down to plain English essentials.
You can't just say, Intel agrees to sell chips to Apple.
Right. You build in every single provision, contingency, and remedy that might protect your client's value or mitigate their risk. The complexity isn't there to confuse people.
It is there because the business reality itself is incredibly complex. Spot on. Which brings us to a really fascinating concept from the framework called the translation skill. The premise here is that a client doesn't hand their lawyer a list of legal doctrines. The client just speaks in business realities.
Yes. A client will walk into the office and say, I need the contractor to finish the lobby renovation by December 1st. And if they don't, I want the ability to fire them or at least penalize their final payment.
So the translation skill is just writing that down in formal language, like making it sound lawyerly.
No, and that is where the danger lies. If you just write down what the client said, even if you dress it up with some fancy formal language, you leave massive gaps.
Okay, so what is the drafter actually doing?
The drafter's job is to translate that raw, two-dimensional business sentiment into very specific legal building blocks. You have to translate finish the lobby into a covenant.
A strict obligation.
Right. You have to translate by December 1st into a condition. You have to translate fire them into a discretionary right of termination. And you have to translate the financial penalty into a specific remedy.
So they're taking a flat business wish and turning it into a three-dimensional legal machine.
Yes. The lawyer is building the machine.
But doing that from scratch for every single deal, that would take hundreds of hours. So what happens in the real world is that drafters use precedents. They pull up a contract they used for a similar deal 3 years ago, or they use, boilerplate language.
Everybody does it.
Right. But the sources issue a massive warning against doing this blindly. But let's be realistic. In a fast-paced commercial environment, relying on precedents is standard practice. Why is it considered so dangerous?
Think of relying on precedent like taking someone else's heavily prescribed medication.
Oh, wow. Okay.
Yeah, you have a headache, right? So you look in a friend's medicine cabinet and take a pill that cured their headache.
Seems logical.
Sure. What you don't know is that their pill was formulated for a specific blood pressure condition you don't have. It might cure your headache, but because your underlying system is different, it causes a fatal allergic reaction.
So the boilerplate language was negotiated for a totally different reality.
Exactly. When you pull a precedent contract from 3 years ago, you are importing all the specific compromises, the unseen leverage dynamics, and the unique risk tolerances of that specific past deal into your client's current deal.
I see. So maybe in that old contract, the buyer agreed to a weak termination clause because they got a massive discount on the purchase price.
Yes. And if you copy that termination clause into a new deal where your client is paying full price, you have just severely compromise their legal position without even realizing it.
You introduce undefined terms, you introduce conflicting clauses, it's a mess.
It is a massive risk.
There is a phenomenon described in the framework that perfectly illustrates the mechanics of how these mistakes happen. It's called the cascade effect.
Oh, the cascade effect. It's a drafter's nightmare.
I want to really spend some time on this because it shows how one minor change to a business term can completely destroy the legal integrity of a contract if the drafter isn't paying attention.
The cascade effect happens when you alter one variable, but fail to trace the implications of that variable through the rest of the document.
Let's build a hypothetical to really track this for the listener. Let's say you are drafting an employment agreement for a new C-level executive.
Okay, pretty standard.
The initial term sheet is very straightforward. A base salary of $200,000 and a standard termination clause that says if the executive is fired for cause, they only receive their base salary up to the exact day of termination. No severance.
Simple enough.
You draft the document, it looks airtight. Then, right before signing, the business teams agree to throw in an annual performance bonus of $50,000 to sweeten the pot.
On the surface, the client just calls you up and says, hey, go into the payment section and add a line about a $50,000 bonus. It sounds like a 5-minute fix.
Right, just type it in and hit print. But the cascade effect dictates that this new variable infects the entire document.
It absolutely does. The moment you introduce the concept of a bonus into the payment section, you have to follow the cascade. You immediately have to look at the termination section. Because if the executive is fired for cause in November, do they forfeit the entire bonus? Or do they get a prorated amount for the 10 months they worked?
Oh, wow. What if they are fired without cause?
Exactly. What if the company is acquired and the executive's position is eliminated entirely? Does the bonus vest immediately?
I didn't even think of that. What if the bonus is tied to company revenue, but the executive is fired before the revenue numbers are audited?
Right. If you simply added the bonus to the payment section and failed to update the termination, severance, and change of control provisions to account for it, you haven't just made a typo.
You have created a massive financial dispute.
Yes. When November rolls around and the executive is fired, they are going to demand that $50,000. The company will refuse, and because the contract is silent on the mechanism, you are going straight to litigation.
It is identical to writing a complex software program. If you change a variable on line 10, but you forget to update the function on line 400 that relies on that variable, the code doesn't just look messy. The entire program crashes.
That is the perfect way to look at it. And to carry that coding analogy forward, you cannot write functional software if you do not fundamentally understand your basic commands.
Like your loops, your strings, your booleans.
Exactly. In contract drafting, those basic commands are the contract concepts, the building blocks.
So let's get into the nuts and bolts of those blocks. According to the framework, every single commercial contract, no matter how complex, can be deconstructed into 7 foundational concepts.
So 7 building blocks.
Right. Representations, warranties, covenants, rights, conditions, discretionary authority, and declarations. Now, I have to push back a little here. Are we really saying that a 1,000-page merger agreement and a 2-page vendor contract are built out of the exact same 7 pieces?
Yes, they really are. Just like every piece of literature in the English language is built from the same 26 letters.
Okay, that makes sense.
The complexity doesn't come from a new type of legal concept. It comes from how intricately these 7 blocks are layered and sequenced together. If you misidentify which block you are supposed to be using, you alter the entire legal reality of the agreement.
All right, let's start with the most famous pairing in contract law, representations and warranties. You almost never see one without the other. It is always the seller represents and warrants. Why are they invariably glued together?
Because they serve 2 distinct functions that, when combined, create an airtight safety net. A representation is a statement of past or present fact made at a specific moment in time.
It's like taking a snapshot of reality.
Yes. It is a statement designed to induce the other party to enter into the contract. For example, the seller represents that the manufacturing equipment is in full working order as of today.
So it is just declaring a reality.
Correct. A warranty, however, is a promise. It is a contractual promise that if the statement made in the representation turns out to be false, the maker of the statement will indemnify or financially compensate the other party for any damages they suffer as a result.
Okay, but if a warranty is the mechanism that actually guarantees payment, why do we need the representation? Why not just say, the seller promises to pay if the equipment is broken? Why go through the ritual of representing the fact first?
Because of the underlying avenues of law they open up. A representation ties into tort law, specifically the tort of misrepresentation or fraud. A warranty ties into contract law, specifically breach of contract.
Oh, interesting. Let's explore the friction there. If the seller just represents the equipment works and it turns out it's broken, what is the reality of that lawsuit?
It is a total nightmare. If you only have representation, your client has to sue for promissory fraud. To win a fraud claim, you generally have to prove scienter.
Which means?
You have to prove the seller knew the statement was false when they made it, or that they were recklessly indifferent to the truth.
And proving what someone knew in their head is incredibly difficult.
Almost impossible without massive amounts of discovery, internal emails, depositions. It is a long, expensive, messy litigation process.
But if they added the word warrants...
If you add the word warrants, you pull the dispute into contract law. It becomes a strict liability issue.
Meaning you don't care about their state of mind.
You don't care at all. You simply prove two things. The equipment was broken, and they promised to pay if it was broken. It is a vastly simpler, faster, and cheaper path to making your client whole.
That is brilliant.
By using represents and warrants together, a drafter gives their client the option to pursue both a simple breach of contract claim and, if the behavior was truly egregious, a fraud claim for punitive damages. You cover the entire spectrum of liability.
That is fascinating. Skipping a single word forces you into an entirely different branch of the justice system. Okay, let's move to the next pair. Covenants and rights.
Right. So a covenant is an ongoing promise to do something, or to refrain from doing something in the future. It creates a strict duty to perform.
Like, the buyer shall pay $10,000 on the first of the month.
Exactly. The right is simply the flip side of that transaction. It is the entitlement to receive the benefit of that performance. The seller has the right to receive the $10,000.
The sources outline a pressure testing mechanism for drafting covenants called the who, what, when, where, why, how, and how much test. Now, I understand the need for detail, but in the final 48 hours of closing a complex deal, drafters are writing dozens of minor covenants. They don't have time to run a 7-part diagnostic on every single sentence. How is this actually applied?
Well, it becomes an internalized checklist. You don't need a spreadsheet, but your brain has to automatically flag missing elements.
Give me an example.
If you write, the developer shall upgrade the security software, the internal alarm has to ring, upgrade it to what standard, by what date, who pays for the license.
If you leave any of those questions unanswered, you have drafted an ambiguous covenant.
Which means you have drafted a dispute.
There is an example in the framework that perfectly highlights the danger of a poorly conceived covenant. Let's talk about the Paul McCrary concert scenario.
Oh, this is a great one.
Imagine your client, an event production company, is signing a contract to rent a massive stadium for a 4th of July festival. The stadium owners insist on a clause that states, the production company shall present a concert on July 4th at which Sir Paul McCrary is the lead act.
Any deal lawyer reading that sentence should immediately pull the fire alarm.
Why? I mean, they want Paul McCrary.
Because it is a strict covenant requiring a result the client cannot control. Sir Paul McCrary is a human being.
What if his flight gets grounded?
Or what if he loses his voice? What if he just decides to retire the week before?
By using the word shall, the drafter has created an absolute duty to perform.
Exactly. If Paul McCrary gets laryngitis and cannot perform, your client is in breach of contract. They are strictly liable.
Wow. Even though it's not their fault.
Doesn't matter. The stadium could sue them for lost revenue, lost concession sales, and reputational damage. You have allowed your client to guarantee the behavior of a third party over whom they have absolutely no authority.
But the stadium wants a guarantee. The business reality is that the stadium won't rent the space unless they know a major star is coming. How do you triage this?
You change the standard of the covenant from a guarantee of result to a guarantee of effort.
How does that read?
You draft it to say, the production company shall use its commercially reasonable efforts to secure Sir Paul McCrary to perform as the lead act.
I see.
Or you require the production company to secure a binding contract with the artist before signing the stadium deal. But you never, ever let a client take on a strict covenant for an event outside their control without an ironclad force majeure or contingency clause attached to it.
That pivots us perfectly into the next building block, conditions. The framework divides these into walkaway conditions and ongoing conditions.
Right. So a condition is a state of facts that must exist before a party has an obligation to perform. It is the ultimate if-then gateway.
Give us an ongoing condition.
An ongoing condition manages the daily flow of the contract. For example, in a construction loan, if the architect certifies that the foundation is complete, then the bank must disburse the second tranche of funding.
The condition must be met before the duty triggers.
Precisely.
But a walkaway condition operates on a much larger scale.
Yes. A walkaway condition, which is also known as a condition precedent to closing, governs whether the deal happens at all. Think of a real estate transaction.
Like getting a mortgage?
Exactly. If the buyer secures a mortgage at an interest rate no higher than 5% by Friday, then the parties must close the transaction.
So what happens if the bank denies the mortgage or offers a 7% rate?
The condition fails. And the beauty of a walkaway condition is that if it fails, the party protected by it can simply walk away from the deal.
The contract dissolves, the deposit is returned, and nobody is in breach. Nobody gets sued.
Right. It's a clean exit.
And this is where mixing up the building blocks becomes fatal, right? What if a tired grafter writes, "The buyer shall secure a mortgage by Friday," instead of "if the buyer secures a mortgage"?
They have just turned a condition into a covenant.
Wow.
Yeah. If they write shall, they have created a strict duty. So if the bank denies the mortgage, the buyer cannot just walk away. They are now in breach of contract.
The seller can sue them for failing to secure the mortgage.
Exactly. A single word change transforms a safe exit strategy into a catastrophic liability.
That is terrifying. Okay, the final two blocks are discretionary authority and declarations.
Discretionary authority gives a party a choice, a permission, or a right to act, but not an obligation. The signal word here is always may.
The landlord may terminate the lease if the tenant fails to pay rent for 2 consecutive months.
Perfect example. The landlord isn't forced to terminate the lease, but they have the absolute authority to do so if they choose.
And declarations.
Declarations are the structural realities of the contract. They are facts that both parties agree are true for the purposes of the relationship. They govern the policies and definitions.
Like the governing law of this agreement is the law of the state of Delaware.
Or the purchase price is $5 million. You draft these in the present tense because they are not actions happening in the future. They are a constant state of being for the life of the document.
So, synthesizing this, the difference between a good drafter and a dangerous one is the ability to look at a business goal and select the exact right building block to execute it.
That's the art of it.
But knowing the blocks is only half the battle. You still have to assemble them into a sentence that doesn't collapse under pressure. Which brings us to the mechanics of a clause. We're going to run a before and after workshop on a specific piece of drafting.
This is where the theory hits the road. Structural analysis is how you cure ambiguity before the ink dries.
Here is the before clause. This is a classic boilerplate sentence that I guarantee is sitting in thousands of active contracts right now. Quote, "Contractor shall promptly notify employer if delays occur."
It looks so harmless, but it is a litigator's dream.
Let's tear it apart. I'll look at this from the perspective of a jaded business owner. I have signed contracts with this exact phrasing. What is the real, tangible harm here?
The harm is that every single substantive word in that sentence is subjective, which means every single word has to be interpreted by a judge if things go wrong. Let's start with promptly. What does promptly mean?
I mean, I would think right away.
But if this is a fast-moving software sprint, promptly might mean within 2 hours. If it is a 5-year infrastructure project building a bridge, promptly might mean within 30 days.
Okay, so the timing is vague. But surely a delay is a delay.
Is it? Who defines what constitutes a delay? If a supplier is 2 hours late delivering concrete, is that a delay that requires formal notification? What if it rains for half a day? The clause doesn't set a threshold.
Oh, I see. And even if I do notify them, what is supposed to happen next?
Exactly. The clause is a cliffhanger. It creates an obligation to notify, but it provides no consequence.
Does the employer have the right to fire the contractor? Does the contractor get an automatic extension on the deadline?
Because the contract is silent, the parties are going to argue about the outcome, which defeats the entire purpose of having a contract.
So how do we rebuild it? The framework suggests a well-drafted action clause requires 4 distinct elements: a trigger, a specific notice period, required information, and a consequence. Let's build the after clause.
Let's do it. We start with the trigger. We need an objective threshold. So let's draft. If a force majeure event delays the contractor's material performance for a continuous period of more than 48 hours.
Okay, we've eliminated the subjective delay. We have a defined term, force majeure event, and a measurable timeline, 48 hours. What about the notice period? We need to kill the word promptly.
The contractor shall notify the employer in writing no later than 3 business days after the 48-hour period expires.
Very precise. Now, the required information. What actually goes in this notice?
The notice must detail the specific cause of the delay, the steps being taken to mitigate it, and the revised estimated time of completion.
And finally, the consequence, the resolution to the cliffhanger.
If the contractor provides this notice in compliance with this section, the deadline for completion is extended by a period equal to the duration of the force majeure event.
Let me read the entire rebuild clause. If a force majeure event delays the contractor's material performance for a continuous period of more than 48 hours, the contractor shall notify the employer in writing no later than 3 business days after the 48-hour period expires. The notice must detail the specific cause of the delay, the steps being taken to mitigate it, and the revised estimated time of completion. If the contractor provides this notice in compliance with this section, the deadline for completion is extended by a period equal to the duration of the force majeure event.
It is longer, yes, but it is bulletproof. A project manager can read that and know exactly what to do, when to do it, and what the result will be without ever having to call their legal department.
To make clauses like that readable, the framework heavily emphasizes a formatting technique called tabulation.
Tabulation is arguably the most effective structural tool in a drafter's arsenal. It is the practice of breaking dense narrative paragraphs into indented alphanumeric lists, your A, B, and C structures.
Why is it so crucial? Isn't it just an aesthetic choice, like making it look pretty on the page?
It is not just aesthetic, no. It cures what linguists and lawyers call syntactic ambiguity. When you bury 3 conditions and 2 exceptions into a single block paragraph, the reader loses track of what modifies what.
It just becomes a wall of text.
Exactly. Tabulation forces the drafter to organize their logic sequentially. It introduces white space, which allows the brain to parse complex conditions. It also acts as a forced diagnostic test for parallel grammar. If your list items don't read properly when attached to the lead-in sentence, you instantly know your grammar is broken.
You mentioned syntactic ambiguity. The sources detail 3 specific types of ambiguity that destroy contracts: semantic, syntactic, and contextual. We need to explore these deeply because this is where the microscopic translation failures happen.
Let's start with semantic ambiguity. This occurs when a specific word has multiple, equally valid dictionary definitions, and the context doesn't clarify which one was intended.
The classic example is money. If a contract simply says the purchase price is $10,000 and the buyer is an American company but the seller is Canadian, you have a massive problem.
You have a 30% fluctuation in value based entirely on semantic ambiguity. Is it USD or CAD?
Right.
Another common semantic failure is the word bi-weekly. Does it mean twice a week or once every 2 weeks? The dictionary allows both.
Oh yeah, I always get that confused myself.
Right. If you require a contractor to submit bi-weekly reports, you are going to end up in a dispute over the delivery schedule. A drafter must recognize words with dual meanings and replace them with precise measurements.
Syntactic ambiguity is a bit more complex. It's about grammar and structure.
Syntactic ambiguity is about modifiers. It occurs when it is unclear which words or phrases in a sentence are being modified by other words. A perfect example from the framework is the sentence, "The sellers shall sell their shares."
That sounds incredibly straightforward.
It does until you apply it to reality. Imagine there are 3 sellers. Are they each individually obligated to sell their own specific block of shares? Or are they jointly obligated to sell a collective pool of shares?
Why does that distinction matter?
Because of liability. If it is a joint obligation and seller A refuses to sell, sellers B and C are now in breach of contract for failing to deliver the collective total.
Wow.
But if it is an individual obligation, seller A is in breach, but B and C are safe. The syntax of "their shares" doesn't answer the question. You have to fix the syntax by writing "each seller shall sell its shares" or "the sellers shall jointly sell the shares."
The third type is contextual ambiguity. This seems to be the most insidious because it doesn't exist in a single sentence. It exists in the architecture of the whole document.
Contextual ambiguity happens when 2 perfectly clear clauses contradict each other when read together. It is incredibly common in large agreements because different teams draft different sections.
Right, the M&A team does one part, the real estate team does another.
Exactly. For example, Article 2 of a commercial lease says, "The tenant is responsible for all structural maintenance of the building." But 60 pages later, in Article 14, an exception says, "The landlord shall maintain the lobby and all common areas."
So a water pipe bursts in the lobby ceiling, destroying the structural drywall. Who pays to fix it?
The lawyers pay to fix it using the money they bill the client to litigate it. The clauses are in direct conflict. Does the specific lobby clause override the general structural clause? Contextual ambiguity requires a drafter to have a holistic understanding of the entire agreement, ensuring internal consistency across hundreds of pages.
This brings us to the drafting language workshop. We've covered mindset, we've covered structure. Now we're getting out the scalpel. We are looking at the specific radioactive words in the legal dictionary that trigger these disputes.
The danger words.
And we have to start with a crusade against the misuse of the word shall. Why is there so much vitriol directed at a single auxiliary verb?
Because shall is the most abused word in the legal profession. Lawyers sprinkle it over a document like magic legal dust to make things sound formal and binding.
I've definitely noticed that. Everything is shall.
But the strict rule of contemporary drafting is absolute. Shall must be used exclusively to mean has a duty to. It is the engine of a covenant.
But lawyers use it for everything. The definition of an employee shall mean, or the contract shall terminate on Friday.
And every time they do that, they are creating what the framework calls a false imperative.
Let me push back on this, though. If a contract says the definition of an apple shall mean a red fruit, everyone knows what it means. It's a definition. Is it really a legal trap, or are drafters just being pedantic?
It is a trap because you are commanding a concept to perform a duty. Words do not have duties. Only legal persons or entities have duties. If you say the definition shall mean, you are theoretically suggesting that the dictionary is going to breach the contract if it fails to mean a red fruit.
Okay, that sounds silly.
It does, but courts have seized on this sloppy drafting to invalidate clauses. If you use shall to mean a duty in one paragraph and use it to declare a definition in the next, a hostile litigator will argue that the word has no fixed meaning in your contract.
Oh, I see. They'll use the ambiguity against you.
They will use your sloppy shall to unravel the strict duties you actually care about.
The framework provides very strict diagnostic tests to hunt down and eliminate these false imperatives. Walk me through the tests for a bad shall.
Okay, the first test. It is wrong if no legal party precedes it. If you write, the rent shall be paid on the first of the month, that is a passive voice disaster. Who have the duty, it must be active. The tenant shall pay the rent.
Second test.
It is wrong if it is coupled with a form of the verb to be. For example, the affected party shall be excused from performance. You cannot have a duty to be excused. Being excused is a state of reality. It is a declaration.
So it should just read, the affected party is excused.
Exactly, just state it.
What about combining it with to have?
That is the third test, and it's incredibly common. The landlord shall have the right to inspect the premises. Having a right is not a duty. You aren't mandating that they inspect it. It is discretionary authority. It should read, the landlord may inspect the premises.
There's also a firm rule about conditional clauses, right?
Yes. Shall is always wrong in an if clause. If the buyer shall fail to secure financing, no. A condition is not a duty, it is a state of facts. If the buyer fails to secure financing, the shall belongs in the consequence, then the seller shall return the deposit.
So if shall is locked down exclusively for duties, what word are we supposed to use to describe things happening in the future?
You use will. Will is used to state a future fact, usually regarding the actions of a non-party. For example, the contractor shall hire a surveyor who will map the property. The contractor has the present duty shall to hire someone who is going to act in the future will.
It requires an incredible amount of discipline to strip shall out of your vocabulary when it doesn't mean a duty. Let's move to another linguistic grenade. And/or. I use and/or in emails constantly. Bring coffee and/or tea. It is efficient. Why do judges despise it so much?
Judges despise it because it is inherently evasive. In an email about coffee, efficiency is fine. In a contract determining liability, efficiency that sacrifices clarity is malpractice. And/or is actually three different choices masquerading as one.
It means A, or B, or both.
Correct. So imagine a penalty clause that reads, the contractor is liable for damages if they are negligent and/or reckless. A dispute arises. The contractor was negligent, but not reckless. They argue the clause required both.
And the employer argues the clause required either.
Exactly. The judge is now forced to guess what the parties intended. Supreme Court justices have written scathing opinions calling and/or an abomination of the English language.
So what is the fix?
Write exactly what you mean. If you mean A or B or both A and B, you write exactly that. If the contractor is negligent or reckless or both, it takes 3 extra words and completely eliminates the ambiguity.
Next on the list of drafting traps is what I like to call the proviso plague. The phrase provided that, or provided, however. Lawyers are obsessed with this phrase. It sounds incredibly sophisticated.
It is the ultimate crutch for lazy drafting. It sounds lawyerly, but legally, a proviso is a chameleon. It can mean three totally different things, and the text rarely provides the context to know which one is intended. It can act as a condition, an exception, or an addition.
Let's dissect the example from the framework, which comes from the Nowicki divorce case. This is a real dispute over asset disclosure. The clause in the settlement read, Mr. Nowicki shall disclose his assets, provided that Mrs. Nowicki discloses hers.
It is a textbook example of fatal ambiguity. What exactly does that proviso mean? Let's look at the first interpretation. It could be a condition, meaning if.
So Mr. Nowicki has absolutely no obligation to do anything unless Mrs. Nowicki acts first. If she discloses, the condition is met and his duty triggers.
Right. That's one interpretation. Okay, what is the second interpretation?
It could be an addition, a mutual covenant, meaning and. Mr. Nowicki has a duty to disclose his assets, and Mrs. Nowicki has a duty to disclose hers.
Those are vastly different legal realities.
Completely different. Under the first interpretation, the condition, if neither party discloses their assets, no one is in breach of contract.
Because the condition wasn't met.
Right. But under the second interpretation, the addition, if neither party discloses, they are both in breach of contract.
Exactly.
How did the court rule?
The court had to parse extrinsic evidence to guess what the divorcing couple intended. It wasted immense time and money. The rule for drafters is uncompromising. Purge provisos entirely. Do not use provided that.
So what do you use?
If you mean a condition, use if. If you mean an exception, use except. If you mean an addition, use and. Say what you mean.
Let's talk about a word that seems completely innocuous but causes massive litigation. Including. This brings up the debate of restrictive versus illustrative language.
Yes. The question is whether including introduces an exhaustive list or merely a list of examples. Imagine you are drafting a commercial lease for an office building. The landlord insists on a clause. The tenant shall not keep any animals on the premises, including dogs and cats.
Okay, so I sign that lease, and the next day I bring in my pet iguana. The landlord tries to evict me. I argue that the list was restrictive. It specifically said dogs and cats, and iguana is neither.
And you might very well win that eviction hearing.
Really? Even though the general category is an animal?
Yes, because courts are sharply divided on how to interpret including. Some jurisdictions rule that including naturally implies enlargement, that dogs and cats are just illustrative examples of the broader banned category of animals.
But other courts don't.
Right. Other jurisdictions apply a strict legal canon of construction known as expressio unius est exclusio alterius.
Ambiguous.
The expression of one thing is the exclusion of the other. These courts argue that if the drafter took the time to specifically list dogs and cats, they intentionally meant to exclude everything else. If they wanted to ban iguanas, they would have written iguanas.
Wow. So how does a drafter avoid playing Russian roulette with different jurisdictions?
By explicitly defining the nature of the word. Risk-averse drafters will always use the phrase including but not limited to or including without limitation. If lease says animals including without limitation, dogs and cats, your iguana argument is instantly destroyed. The landlord evicts you and there is no debate.
The final major trap involves time, numbers, and dates. Specifically, the insidious preposition within. You see this constantly. Notice must be given within 30 days of the closing date.
It is a scheduling disaster waiting to happen. Within 30 days of closing is wildly ambiguous. Does it mean notice must be given in the 30 days before the closing? Does it mean the 30 days after the closing? Or does it mean a 60-day window sandwiching the closing?
And what about the actual day of closing? Is that day 0 or day 1?
Exactly. You are leaving the calculation of a critical deadline open to interpretation. The fix is to eliminate the preposition within and replace it with a measurable unidirectional timeline.
Like what?
You draft no later than 30 days before the closing date or no later than 30 days after the closing date. You anchor the timeline precisely.
I am marveling at the sheer gravity of this. A single shall instead of an if, a misguided and/or, a failure to add without limitation, or a sloppy preposition can literally shift tens of millions of dollars in liability from one corporate balance sheet to another.
It happens every day.
It really reinforces the idea that using dense legalese isn't a sign of a lawyer being smart or sophisticated. It is usually a sign of lazy drafting. It is relying on archaic formulas instead of doing the brutal, granular work of thinking through the mechanics of a specific deal.
That is the ultimate takeaway. The goal of all this microscopic agonizing over individual words is macroscopic peace. Whether you are structuring the overarching architecture of the document, from the preamble down to the endgame provisions, or you are staring at a single sentence trying to decide between shall and must, your singular objective is absolute clarity.
Right.
A truly well-drafted contract is invisible. It does its job silently in the background. It gets signed, it gets put in a file drawer, and it never sees the light of day again because there is absolutely nothing for the parties to argue over.
Which is the dream for the client paying the legal bills. But as we wrap up this deep dive, I want to throw a curveball at you.
Okay, I'm ready.
We have spent an immense amount of time relentlessly hunting down ambiguity. But in the deeper footnotes of contract design and negotiation theory, there is this fascinating concept called strategic vagueness.
Ah, yes. Intentional ambiguity.
Right. What if, sometimes, ambiguity is not a failure of drafting, but a deliberate feature of the deal? Imagine those two business teams at 3:00 a.m. They have agreed on 95% of the merger. But they are completely deadlocked on exactly what standard of effort a party has to use to secure regulatory approval.
It happens a lot. They hit a wall.
Neither side will budge.
Yeah.
So instead of blowing up a billion-dollar deal over this one issue, they intentionally use a vague phrase like commercially reasonable efforts or material adverse change. They purposefully choose not to define it. They basically look at each other and say, we have deal fatigue, let's just sign this now, leave it murky, and if it explodes in 2 years, we'll let a judge figure it out.
It is a very real phenomenon. It completely challenges the psychology of the drafter. We preach perfect clarity, but human nature and commercial pressure sometimes demand a little bit of wiggle room to simply get the deal across the finish line.
So they just pass the buck to the future.
Exactly. When parties cannot agree on a precise rule, they agree on a vague standard, essentially outsourcing the final negotiation to a future arbitrator or court.
It is a calculated gamble. They are betting that the relationship will hold and that the vague clause will never actually be tested. It means that sometimes the murky X-ray isn't a sign of a broken machine or an incompetent doctor. Sometimes a murky X-ray is exactly what the patient ordered just to get out of the hospital.
It is a fascinating paradox, but it underscores the ultimate point. Whether you are eliminating ambiguity or strategically employing it, you must be doing it intentionally.
A brilliant distinction. Something for you, the listener, to mull over the next time you are reading the fine print. Thank you for joining us on this deep dive into contract architecture. I encourage you to take these tools, the building blocks, the structural test, the translation skill, and look at every vendor agreement, every terms of service, and every lease with a brand new set of eyes.
You'll see them everywhere.
You really will. Look for the false imperatives. Look for the cascade effects. I guarantee you will never read the word shall the same way again.
You certainly will not.
Knowing how to read the clear lines is essential, but knowing how to navigate the murky ones is where the real leverage lies. Until next time.